Hello and welcome to Bar 10 Test Prep, lesson number 59. It's our goal to help you prepare for the bar exam 10 questions at a time, and to that end, we've uploaded this lesson as well as 58 prior lessons. Let's get right into it. Question number 1. Tenant rented a commercial building from landlord and operated a business in that building. The building's large front window was smashed by vandals 6 months before expiration of the tenant-landlord lease. Tenant, who was obligated thereunder to effect and pay for repairs in such cases, promptly contracted with Glazier to repair the window for $2,000, due 30 days after satisfactory completion of the work. Landlord was then unaware of the tenant-Glazier contract. Glazier was aware that the building was in fact under lease, but dealt entirely with the tenant. 60 days after Glazier's satisfactory completion of the window replacement and prior to the expiration of tenant's lease, tenant, then insolvent, ceased doing business and vacated the building. In so doing, tenant forfeited, under the lease provisions, its right to the return of a $2,000 security deposit with the landlord. The deposit had been required, however, for the express purposes of covering any damage to the leased property except under ordinary wear and tear circumstances. The only such damage occurring during tenant's occupancy was in fact the smashed window. Glazier's $2,000 bill for the window replacement is wholly unpaid. Assuming that Glazier has no remedy quasi in rem under the relevant state mechanics lien statute, which of the following would provide Glazier's best chance of an effective remedy in personam against landlord? Option A, an action in quasi-contract for the reasonable value of a benefit unofficiously and non-gratuitously conferred on landlord. Option B, an action based on promissory estoppel. C, an action based on an implied in-fact contract. Or Option D, an action as third-party intended beneficiary of the tenant-landlord lease. Take a few seconds and see if you can choose the best answer now. If you chose option A, you'd be right and off to a great start, so I'm hoping that you did. A, an action in quasi-contract for the reasonable value of a benefit unofficiously and non-gratuitously conferred on the landlord. Remember that in contract theory, when theory fails to produce a just result, quasi-contract is available as an equitable doctrine to prevent the unjust enrichment of one of the parties. A quasi-contract arises where one party confers a benefit upon the other with the reasonable expectation that they'll receive payment for that benefit. Unlike contract damages, however, measures for damages in quasi-contracts are limited to restitution. Here, Glazier contracted with tenant to replace the window for $2,000. Glazier was aware the building was under lease, and he conferred a benefit to landlord by replacing the building's large front window. When tenant then subsequently became insolvent and vacated the building, Glazier was left with an unpaid bill for $2,000 for repairing a window on the landlord's property. Now, landlord, in fact, had a $2,000 security deposit on behalf of that particular tenant. Glazier's best option, given those circumstances, would be to assert an action in quasi-contract for restitution because landlord has been unjustly enriched. He's been unjustly enriched dually, actually, as a matter of fact, because he is now in possession of the security deposit from tenant, and he's also in possession of the benefit of the repaired window on the part of Glazier. Glazier, however, in fact, is harmed because he did the work, he presented the glass, and in fact has an unpaid bill. None of the other options really address this concern. So as a result, option A is without question your very best option here and the correct answer. Let's move on to question number 2. Tenant rented a commercial building from landlord and operated a business in it. The building's large front window was smashed by vandals 6 months before expiration of the tenant-landlord lease. Tenant who was obligated thereunder to effect and pay for repairs in such cases promptly contracted with glazier to replace the window for $2,000 due 30 days after satisfactory completion of the work. Landlord was then unaware of the tenant-glazier contract. Glazier was, however, aware that the building was under lease, but dealt entirely with tenant. 60 days after glazier's satisfactory completion of the window replacement, and prior to the expiration of tenant's lease, tenant, then insolvent, ceased doing business and vacated the building. In so doing, tenant forfeited, under the lease provisions, its right to return of a $2,000 security deposit with landlord. The deposit had been required, however, for the express purposes of covering any damage to the leased property except ordinary wear and tear. The only such damage occurring during tenant's occupancy was the smashed window. Glazier's $2,000 bill for the window replacement is wholly unpaid. For this question only, assume the following facts. Upon vacating the building, tenant mailed a $1,000 check to Glazier, bearing on its face the following conspicuous notation. This check is in full and final satisfaction of your $2,000 window replacement bill. Without noticing this notation, Glazier cashed the check and now sues tenant for the $1,000 difference. If tenant's only defense is accord and satisfaction, is tenant likely to prevail? Let's take a look at our four options here as answers. A, no, because Glazier failed to notice tenant's notation on the check. B, no, because the amount owed by tenant to Glazier was liquidated and undisputed. C, yes, because by cashing the check, Glazier impliedly agreed to accept the $1,000 as full payment of its claim. Or D, yes, because Glazier failed to write a reservation of rights notation on the check before cashing it. Take a few seconds, choose the best answer. If you chose option B, then you continue to be on a roll here. No, because the amount owed by tenant to Glazier was liquidated and undisputed, and accords an agreement to accept a different performance and satisfaction of the existing obligation. However, the rule is that if a debt is due and undisputed, part payment is now new consideration for settlement of the release. In this case, there's no agreement between Glazier and tenant for Glazier to accept the $1,000 as the lower fee instead of the original $2,000 fee. Furthermore, since the debt owed by the tenant to Glazier was due and undisputed, there was no issue as to it. It was clear that the amount owed on that contract was $2,000. This part payment does not qualify as new consideration for settlement or release. As such, tenant will not prevail with the defense of accord and satisfaction if these are the facts that he presents before a judge. Let's look at the other options and see why they're incorrect. Option A, no, because Glazier failed to notice tenant's notation on the check. It's really irrelevant because at the end of the day, what we're focusing on is that this was an undisputed claim. There was a set number in the contract. That number is what the debt was. Now, any new attempt to change that number does not come with any new consideration. As such, does not affect the original contract. Let's look at option C. Options C and D are similarly incorrect. Let's look at C first. C, yes, because by cashing the check, Glazier impliedly agreed to accept the $1,000 as full payment of its claim. No, simply by cashing the check, he's accepting payment. However, the terms of this new offer, the terms of this new agreement, are not met with any consideration. So as a result, in fact, they are invalid. D, yes, because Glazier failed to write a reservation of rights notation on the check before cashing it. Just like C, it's irrelevant. Arguably, there is no dispute as to the underlying amount that's owed. So as a result, the reservations of rights would have been wholly unnecessary because the claim in full satisfaction of the debt would have not been appropriate and in essence would have been deemed a legal nullity. If you chose option B, recover under the provisions of the UCC, you'd be correct, although the UCC ordinarily requires contracts to specify the amount of goods to be provided in a requirements contract. It is sufficient that the buyer agrees to buy all of its requirements from the seller and to buy exclusively from that seller. In this case, the Tires County contract stated that Tires will deliver all tires required by this agreement to County. There was no definite quantity of tires specified in the contract. If the court concludes that the Tires County contract is an agreement by County to buy its tire requirements from Tires, then the court is construing the agreement to be a requirements contract. This means that Tires will probably be able to recover under the UCC for County buying tires from another seller. Thus, the best answer is B. Let's look at the other options and see why they would be incorrect. A, recover under the Contracts Clause of the United States Constitution. This would clearly be inaccurate or invalid because the Contracts Clause of the United States Constitution simply discusses that the state cannot limit the individual's rights to contract, generally stated. That being said, this would not likely be a very good response here, as it's likely not relevant. C, not recover because the agreement lacks mutuality of obligation. Now, that being said, it does have specific obligations if the court interprets this to be a requirements contract. If it does, then the county is to buy all of its needs of tires from the company called Tires, and Tires is to supply all of them. So there is a mutuality of obligation there, an obligation to buy and an obligation to sell. D, not recover because the agreement is indefinite as to quantity. Remember, if this is deemed a requirements contract, UCC states that there is no quantity necessary. The quantity is the totality of the needs, which is in fact a number. While not being a real number, it is a number nonetheless. It is the entirety of the needs. It is all. Question number 4. Peter, who was 20 years old, purchased a new high-powered sports car that was marketed to an intended and recognized appeal to youthful drivers. The car was designed with the capability to attain speeds in excess of 100 miles per hour. It was equipped with tires designed and tested only for a maximum safe speed of 85 miles per hour. The owner's manual that came with the car stated that the continuous driving over 90 miles per hour requires high-speed capability tires, but the manual did not describe the speed capability of the tires sold with the car. Peter took his new car out for a spin on a straight, smooth country road where the posted speed limit was 55 miles per hour. Intending to test the car's power, he drove for a considerable distance at over 100 miles per hour. While he was doing so, the tread separated from the left rear tire, causing the car to leave the road and hit a tree. Peter sustained severe injuries. Peter has bought a strict product liability action and tort against the manufacturer of the car. You should assume that pure comparative fault principles apply to this case. Will Peter prevail? Let's look at our options. A, no, because Peter's driving at an excessive speed constituted a misuse of the car. B, no, because the car was not defective. C, yes, if the statement in the manual concerning the tires did not adequately warn of the danger of high-speed driving on the tires mounted on the car. Or D, yes, unless Peter's driving at a speed in excess of the posted speed limit was negligence per se, that by the law of the jurisdiction was not excusable. Take a few seconds and choose what you believe to be the best answer now. Well, I hope you chose option C, yes, if the statement in the manual concerning the tires did not adequately warn of the danger of high-speed driving on the tires mounted on the car. Remember, the general rule is that a seller of a product is strictly liable for injuries caused by defective products. Even if a product is properly designed and properly manufactured, the manufacturer can still be liable if the product has a non-obvious risk and the manufacturer fails to give adequate warnings or instructions regarding this risk. The defendant will only be liable if the product was either used as intended or the misuse was a reasonable, foreseeable misuse. If the misuse was foreseeable, then the defendant must warn the purchaser against such misuse to avoid any liability. In this case, the high-powered sports car was designed with the capability to attain speeds in excess of 100 miles per hour. It was specifically marketed with an intended and recognized appeal to youthful drivers, while the car's manual stated that continuous driving over 90 miles per hour requires high-capability tires, or high-speed capability tires. There was no indication that the equipped tires were designed and tested only for a maximum safe speed of 85 miles per hour. Peter's driving of the car over a considerable distance at over 100 miles per hour was a reasonably foreseeable misuse, considering that the type of car and the way that it was marketed. The manual may not have adequately warned against the non-obvious risk of this reasonably foreseeable misuse, since there was no mention of the risk of the equipped tires tread separation when driving over 85 miles per hour. Therefore, Peter will likely prevail in a strict product liability action against the manufacturer of the car if the statement in the manual concerning the tires did not adequately warn of the danger of high-speed driving on the tires mounted on the car. Let's look at the three other options and see why they are inaccurate. Let's look at option A. No, because Peter's driving at an excessive speed constituted a misuse of the car. That's a very good point, and that's something that most students might think. The reality, however, was the misuse a reasonably foreseeable misuse? Cars marketed to a younger population. Younger people tend to speed more than anyone else. That's why their insurance premiums usually are higher. They tend to speed and they tend to get into accidents as a result of that speed, more so than anyone else. That being said, if the driving in excess speed is reasonably foreseeable and you have a product where you know that driving over a set speed could cause this danger, failure to give notice of that danger is what creates liability, not the fact that the individual drove the car at an excessive speed for any period of time, if that is reasonably foreseeable. Now, if, for example, he were to use the vehicle to drive across a high wire at a circus and fall and die, that's not a reasonably foreseeable use of the vehicle. But reasonably foreseeable is, without question, a young person or a young man driving at excessive speed if he owns a hot sports car like this. So that being said, that's what the question turns on, as opposed to any actual, in fact, negligence on the part of the driver himself. So A would be inaccurate. B, no, because the car was not defective. B, great, the car is not defective. Now, I'm not certain here if they're attempting to distinguish the cars from the tires, right? Because the tires are obviously a part of the car itself. So in and of itself, the tires may not have been defective, but that's not the issue. The issue is that you provided the tires attached to a hot, fast sports car that can easily drive over 100 miles an hour. You market it as a sports car to younger people, which are inherently going to speed, and you fail to give notice of the fact that driving over 85 miles per hour could cause the tires to be damaged and could cause accidents as a result. That is the issue, not the defect of the car. Doesn't matter that the car was not defective. It matters that the individual wasn't warned of the particular danger, right? Because the car could not be defective, and that's accurate. It's probably not, especially if you keep the car driving under 85 miles per hour. So it would have behooved the defendant to have warned the plaintiff of the danger of driving in excess of 85 miles per hour. And that is what the liability is based on, not the defect or the actual inherent defect of the vehicle itself. D, yes, unless Peter's driving at a speed in excess of the posted speed limit was negligence per se. That, by the law of the jurisdiction, was not excusable. Now, Peter's negligence is one thing, and the defendant's responsibility to inform him of the facts and the reality of the matter are two very different things. Well, let's give an example here, right? It may be that Peter was acting negligently or behaving in a negligent manner as a result of his excess speed. But did he take into account the fact that the tires were not safe to drive at that speed? If he is going into this with a presumption that the vehicle is safe, the vehicle is made to drive at that speed, then he assumes certain risks. So, for example, if he were to not be able to brake and hit someone who happened to jump in front of him, perhaps that would be an assumption of that liability, right? Because he failed to stop as a result of his intentionally driving at an excess rate of speed. However, here the distinction is he's not informed of what could happen. So is he in fact intentionally taking that risk, right? Is he assuming that risk? He is not. He cannot be deemed to have assumed the risk if he wasn't informed of the risk. So as a result, if the defendant was aware of this risk and failed to notify the other parties, especially if it's a reasonably foreseeable misuse, the onus then falls back onto the defendant. Question number 5. 20 years ago, Test, who owned Blackacre, a 1-acre tract of land, duly delivered a deed of Blackacre to school district so long as it is used for school purposes. The deed was promptly and properly recorded. 5 years ago, Test died, leaving Sonny as his only heir, but by his probated will, he left all of my estate to my friend Fanny. Oh boy, that must have been a hit. Last month, school district closed its school on Blackacre and for valid consideration duly executed and delivered a quitclaim deed of Blackacre to owner, who planned to use the land for commercial development. Owner was now brought an appropriate action to quiet title against Sonny, Fanny, and the school district. The only applicable statute is a provision in the jurisdiction's probate code, which provides that any property interest which is descendable is divisible. In such an action, the court should find title is now in A, owner, B, Sonny, C, Fanny, or D, school district. Take a few seconds, choose what you believe to be the best answer now. I hope you chose option C. That would be the correct answer. If you didn't, your property professor is probably waking up in the middle of a nightmare screaming out your name right now. A fee simple determinable is a fee simple that automatically comes to an end when a stated event occurs or fails to occur. A fee simple determinable endures until a named event occurs, and then it automatically reverts to the grantor. It is divisible, subject to condition, descendable, subject to condition, and alienable, subject to condition. A fee simple absolute, on the other hand, is absolute ownership, and it is freely divisible, descendable, and alienable. In this case, school district had Blackacre in fee simple determinable, so long as it is used for school purposes. Blackacre reverts to Test if it ceases to be used for school purposes. Test's duly probated will left all of his estate to his friend Fanny, which means Fanny would take Blackacre in fee simple if it stopped being used for school purposes. School district then sold Blackacre to owner, and owner was not going to use Blackacre for school purposes. This means that title would automatically pass back to Fanny in fee simple. Thus, the court should find that title, in fact, is owned and held by Fanny. I'm not going to analyze the other three options because it's relatively straightforward, but if you got this one wrong, shame on you. Question number 6. Small retailers located in the state of Yellow are concerned about the loss of business to certain large retailers located nearby in bordering states. In an effort to deal with this concern, the legislature of Yellow enacted a statute requiring all manufacturers and wholesalers who sell goods to retailers in Yellow to do so at prices that are no higher than the lowest prices at which they sell them to retailers in any other states that border Yellow. Several manufacturers and wholesalers are located in states bordering Yellow and who sell their goods to retailers in those states, and in Yellow bring an action in federal court to challenge the constitutionality of the statute. Which of the following arguments offered by these plaintiffs is likely to be the most persuasive in light of applicable precedent? The state statute, A, deprives them of their property or liberty without due process of law. B, imposes an unreasonable burden on interstate commerce. C, deprives them of a privilege or immunity of national citizenship. or D, denies them the equal protection of the laws. Take a few seconds. Choose your best answer now. I hope you chose option B, imposes an unreasonable burden on interstate commerce. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce as long as the state law is not protectionist and does not otherwise impose an undue burden on the interstate commerce. This limit on state power, sometimes called the negative implications of the Commerce Clause or the Dormant Commerce Clause, is inferred from the Commerce Clause's grant of power to Congress to regulate interstate commerce. A state or local law that benefits in-state interests at the expense of out-of-state interests is protectionist and imposes an unreasonable burden on interstate commerce. Such a law will be struck down unless it is necessary to achieve an important non-economic state interest. A law that is not protectionist may nevertheless violate the Dormant Commerce Clause doctrine if the burden that the law places on interstate commerce outweighs the public benefit of the law. In this case, the statute is protectionist because it is intended to benefit in-state retailers by guaranteeing them the ability to purchase goods at prices no higher than the lowest prices paid by out-of-state retailers. Since the only purpose for the law is to prevent the loss of business to neighboring states, the law is not necessary to achieve an important non-economic state interest. Therefore, the law imposes an unreasonable burden on interstate commerce and will be struck down for that reason. Now, if we look at the other options, option A deprives them of their property or liberty without due process of law. This would seemingly be inapplicable because there's no property that's being taken away and their freedom or liberty is not at stake. So as a result, A would generally not apply. C deprives them of a privilege or immunity of national citizenship. While this may be accurate, it may not in fact be the very best description here, because the reality is that we're not addressing issues of citizenship or issues of voting or things along those lines of being a part of a state. Instead, we're looking at something that's highly contractual, highly business oriented. D denies them the equal protection of the laws. There is no denial of equal protection, it would seem, based on the facts. The reason for that is that the restriction is generally applicable to all out-of-staters, and the sale price is dictated by the sale price of the same item from the same company in the neighboring areas. So generally, I would tend to think that the equal protection laws is probably not the best course of action to go, while theoretically you could make an argument to say that there's a discriminatory practice from out-of-staters. That being said, the basis of that discrimination is ultimately a Commerce Clause argument. There's interstate commerce. That's what's really the issue here, and that should be relatively easy to pick up from the fact pattern that you have interstate commerce, because there are businesses from different states actually negotiating in interaction. So as a result, B, without question, is the most direct and best answer. While some of the other options may be applicable, they are, in fact, without question, not the very best option as an answer here. Question number 7. A brother and sister, Bruce and Sharon, acquired as joint tenants a 20-acre parcel of land called Greenacre. They contributed equally to the purchase price. Several years later, Bruce proposed that they build an apartment development on Greenacre. Sharon rejected the proposal, but orally agreed with Bruce that Bruce could go ahead on his own on the northerly half of Greenacre, and Sharon could do what she wished with the southerly half of Greenacre. Bruce proceeded to build an apartment development on, and generally developed and improved, the northerly 10 acres of Greenacre. Sharon orally permitted the southerly 10 acres of Greenacre to be used by the Audubon Society as a nature preserve. Bruce died, leaving his entire estate to his son, Stanley. The will named Sharon as executrix of his will, but she refused to serve. In an appropriate action to determine the respective interests of Sharon and Stanley in Greenacre, if Stanley is adjudged to be the owner of the northerly 10 acres of Greenacre, the most likely reason for the judgment will be that A, The close blood relationship between Sharon and Bruce removes the necessity to comply with the statute of frauds. B. Sharon's conduct during Bruce's lifetime stops her from asserting title to the northerly half of the Greenacre. C. The joint tenancy was determined by the oral agreement of Sharon and Bruce at the time it was made. Or D. Sharon had a fiduciary obligation to her nephew Stanley by reason of her being named executrix of Bruce's will. Take a few seconds and choose what you think is the best answer now. I hope you chose option B. That would be the correct option. Sharon's conduct during Bruce's lifetime stops her from asserting title to the northerly half of Greenacre. A joint tenancy means each tenant owns undivided shares with the right of survivorship. Severing any of the four unities required for a joint tenancy, i.e. time, title, interest, and possession, severs the joint tenancy and creates tenancy in common. The possession requirement means each tenant must have the right to possess the whole. Here, Sharon orally agreed with Bruce that he could go ahead with his apartment development on the northerly half of Greenacre, and that she could do what she wished with the southerly half of Greenacre. In accordance with this agreement, Bruce proceeded to build an apartment development on the northerly 10 acres, and Sharon permitted the southerly 10 acres to be used as a nature preserve by the Audubon Society. This agreement, however, did not sever any of the four unities required for the joint tenancy. So the joint tenancy with the right of survivorship seems to have remained in place. As such, if Stanley is adjudged to be the owner of the northerly 10 acres of Greenacre, the most likely reason for the judgment will be that Sharon's conduct during Bruce's lifetime stops her from asserting title to the northerly half of Greenacre. Let's look at the other three options and see why they would be less correct. Option A, the close blood relationship between Sharon and Bruce removes the necessity to comply with the statute of frauds. That's wholly inaccurate. The statute of frauds is, and no close blood relationship would remove the requirements from it nonetheless. Option C, the joint tenancy was terminable by oral agreement of Sharon and Bruce at the time it was made. Now, generally, there is no oral agreement that would violate a joint tenancy. That being said, that would obviously, under the statute of frauds, have to be in writing. But that being said, remember that this does not meet any of the four unions. It doesn't meet a violation of the four unities: time, title, interest, and possession. Nothing has changed as far as the time, nor the title, nor the interest, and with regards to the possession of the property in a whole. So as a result, none of the unities would have been violated. So that would not be an appropriate response. Option D, Sharon had a fiduciary obligation to her nephew Stanley by reason of her being named executrix of Bruce's will. Simply being named as executor or executrix on a will does not necessarily create a fiduciary duty. Accepting that role does. She seems to have challenged the appointment of that role. So as a result, while it may be that she never received fiduciary duty, even if she did, that would not necessarily be dispositive as to why the court would determine that the property, in fact, should be severable. That being said, the absolute basic and best reason why the court would find such a decision is if, in fact, Sharon, during her lifetime, in essence, by her own behavior, has stopped herself from being able to legally make this claim. So as a result, B would be the very best option here. Question number 8. Spender owed Midas $1,000 plus interest at 8% until paid on a long overdue promissory note, collection of which would become barred by the statute of limitations on June 30th. On the preceding April 1st, Spender and Midas both signed a writing in which Spender promised to pay the note in full on the following December 31st, plus interest at 8% until that date, and Midas promised not to sue on the note in the meantime. Midas, having received some advice from his non-lawyer brother-in-law, became concerned about the legal effect of the April 1st agreement. On May 1st, acting pro se, as permitted by the rules of the local small claims court, he filed suit to collect the notes. For this question only, assume that on January 2nd of the following year, Midas's suit has not come to trial. Spender has not paid the note. Midas has retained a lawyer, and the lawyer, with leave of the court, amends the complaint to add a second count to enforce the promise Spender made in the April 1st agreement. Does the new count state a claim upon which relief can be granted? A. Yes, because Spender's failure to pay the note plus interest on December 31st makes Midas's breach of promise not to sue before that date no longer material. B. Yes, because Spender's April 1st promise is enforceable by reason of this moral obligation to pay the debt. C. No, because such relief would undermine the policy of the statute of limitations against enforcement of stale claims. Or D. No, because Spender's April 1st promise was lawfully conditioned upon Midas's forbearing to sue prior to December 31st. Take a few seconds and choose the best answer now. I hope you chose option D, no, because Spender's April 1st promise was lawfully conditioned upon Midas's forbearing to sue prior to December 31st. The rule is that a breach of contract occurs when a party to the contract does not perform after performance, in fact, becomes due. Performance only comes due after the occurrence of all conditions precedent to performance have been, in fact, satisfied. Language in a contract that states something must occur before someone's performance is due is a condition precedent by definition. If the condition is not satisfied, non-performance is then excused. In this case, Spender and Midas signed a writing on April 1st in which Spender promised to pay the note in full on the following December 31st, plus interest at 8% until that date. And Midas promised not to sue on the note in the meantime. Spender's performance would be due on December 31st, but only if Midas had satisfied the condition precedent to Spender's performance, i.e. to not sue on the note in the meantime. As such, when Midas sued Spender on May 1st, he failed to satisfy the condition precedent to Spender's performance, so Spender's performance would in fact be excused. Let's look at the other three options and see why they would be less correct, or more incorrect, better stated. Option A, yes, because Spender's failure to pay the note plus interest on December 31st makes Midas's breach of promise not to sue before that date no longer material. As we just went through our analysis, we see that that is fully incorrect. The lack of suit is a condition precedent to the interest. So the fact that he filed suit, he in essence violated that contract first. So A would be incorrect. B, yes, because Spender's April 1st promise is enforceable by reason of his moral obligation. Let's stop there. There's no such enforceability, so we can eliminate B right off the bat. C, no, because such relief would undermine the policy of the statute of limitations against enforcement of stale claims. This actually makes no literal sense here. We're talking about we cannot go forward here because it would violate the policy of the statute of limitations against enforcement of stale claims. The statute of limitations you'd present would be inapplicable because arguably you could make more of a claim that standing is an issue rather than statute of limitations. So B and C should be eliminated as gimmies. A should be eliminated because it simply misstates the fact. And as a result, D is your very best answer here. Question number 9. Homer and Purcell entered into a valid, enforceable written contract by which Homer agreed to sell and Purcell agreed to purchase Blackacre, which was Homer's residence. One of the contract provisions was that after closing, Homer had the right to remain in the residence at Blackacre for up to 30 days before delivering possession to Purcell. The closing took place as scheduled. Title passed to Purcell, and Homer remained in possession. Within a few days after the closing, the new house next door, which was being constructed for Homer, was burned to the ground, and at that end of the 30-day period, Homer refused to move out of Blackacre. Instead, Homer tendered to Purcell a monthly rental payment in excess of the fair rental value of Blackacre. Purcell rejected the proposal, and that day brought an appropriate action to gain immediate possession of Blackacre. The contract was silent as to the consequences of Homer's failure to give up possession within the 30-day period, and the jurisdiction which Blackacre is located has no statute dealing directly with this situation, although the landlord-tenant law of the jurisdiction requires a landlord to give a tenant 30 days notice before a tenant may be evicted. Purcell did not give Homer any such 30-day statutory notice. Purcell's best legal argument in support of his action to gain immediate possession is that Homer is A, trespasser ab initio, B, a licensee, C, a tenant at sufferance, or D, tenant from month to month. Take a few seconds and choose what you believe is the best answer now. If you chose option B, you'd be correct. A licensee is the mere privilege to use another's land for a specified purpose. A licensee is not subject to the statute of frauds and therefore can be created orally or by writing. A licensee is revocable at any time, at will of the licensor. Here, Purcell wants to gain immediate possession of Blackacre. If Homer is considered a tenant, then Purcell has to give him 30 days statutory notice of eviction. However, as Homer is considered a licensee, then Purcell can revoke the license at any time without any notice and gain immediate possession of Blackacre. Therefore, Purcell's very best legal argument in support of his action to gain immediate possession is that Homer is in fact a licensee and not a tenant. So let's look at the other options. Let's look at option C, a tenant at sufferance, and option D, tenant from month to month. We don't want tenancy. The moment we hear the word tenancy, we know that we have to give 30-day notice. So those would immediately be eliminable from your choices. A trespasser ab initio, that would be inappropriate because he is rightfully there to begin with. So the only thing we're left with is the licensee as an option, or option B. That would be your very best option. Question number 10. Betty Bauer, an adult, asked Jeff Giedis to lend her $1,000. Giedis replied that he would do so only if Bauer's father, Cash, would guarantee the loan. At Bauer's request, Cash mailed a signed letter to Giedis. If you lend $1,000 to my daughter, I will repay it if she doesn't. On September 15th, Giedis, having read Cash's letter, lent $1,000 to Bauer, which Bauer agreed to repay in installments of $100 plus accrued interest on the last day of each month beginning October 31st. Cash died on September 16th. Later that same day, unaware of Cash's death, Giedis mailed a letter to Cash advising that he had made the $1,000 loan to Bauer on September 15th. Bauer did not pay the installments due on October 31st, November 30th, or December 31st, and has informed Giedis that she will be unable to make repayments in the foreseeable future. On January 15th, Giedis is entitled to a judgment against Bauer for which of the following amounts? A, nothing, because if he sues before the entire amount is due, he'll be splitting his cause of action. B, $300 plus the accrued interest, because Bauer's breach is only a partial breach. C, $1,000 plus the accrued interest, because Bauer's unexcused failure to pay 3 installments is, in fact, a material breach. Or D, $1,000 plus the accrued interest, because the failure to pay her debts as they come due indicates that Bauer is insolvent and Giedis is thereby entitled to accelerate payments of the debt. Take a few seconds and choose what you believe is the best answer now. If you chose option B, $300 plus the accrued interest, because Bauer's breach is only a partial breach, you'd be correct. Where a party unambiguously states by words or conduct to the other party before the time for performance has arisen that she will not perform or that she is unable to perform, the other party is entitled to treat that as an anticipatory repudiation. That generally excuses performance by the non-repudiating party and gives rise to an immediate right to sue for recovery. If, however, the non-repudiating party has already completed performance, then the non-repudiating party must wait until the contract becomes due to sue. In this case, Giedis has already completed performance by loaning Bauer the $1,000 on September 15th. Bauer subsequently breached by not paying the installments that were due on October 31st, November 30th, and December 31st, respectively. Furthermore, Bauer also informed Giedis that she would be unable to make repayments in the foreseeable future. This is clearly an anticipatory repudiation, but since Giedis has completed performance, he must wait until the remaining payments are due to recover them. As such, on January 15th, Giedis would only be entitled to a judgment against Bauer for $300. For example, the October, November, and December payments, plus any accrued interest in the interim. Let's look at the other three options and see why they would not be as valid. Option A, nothing, because if he sues before the entire amount is due, he'll be splitting his cause of action. This is inaccurate. He is entitled to sue for the payments that were due up until that point. While this is not, in fact, splitting the contract into smaller contracts or 10 smaller contracts. In fact, to some degree, it in fact is. Each of the payments could theoretically be treated as an agreement in and of itself that has been in fact then subsequently violated. So while the plaintiff would not be able to sue for the entire amount, they would be able to sue for whatever amounts are in fact due at that time. So A would not be accurate. C, $1,000 plus the accrued interest because borrower's unexcused failure to pay 3 installments is a material breach. That may be true. However, that does not accelerate the contract terms, and the terms are that the payment is due by X amount of date. The defendant will have up until that time to make that payment. However, given the fact that the contract specified the breakdown of payments, any missed payments would be due at that point at the time of suit. So C would not be accurate. D, $1,000 plus the accrued interest because the failure to pay her debts as they come due indicates that Bauer is insolvent and Giedis is thereby entitled to accelerate payment of the debt. The fact that Bauer is insolvent is irrelevant. The contract has a specific time frame in which the repayment of the loan is to be made. Those terms will be kept, especially given the fact that the defendant's consideration has fully been paid. So the entire amount has been paid given the fact that there is a debt already in place for the $1,000. If the payments were due over a period of time, that would change things. Yes, as we noted before, the anticipatory repudiation would stop the defendant from having any further obligation. So if this were an ongoing loan, the obligation of the defendant to continue making payments would have ceased once the plaintiff breached the contract. That being said, D is not an appropriate answer here, and B is, without question, the most appropriate answer. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded these 10 questions, and we upload content on a regular basis. Don't forget to like, subscribe, and click the notification bell so you can be updated the next time we upload a new MBE set of questions, which should be 2 times per week on Wednesdays and Sundays. We look forward to working with you again. Good luck, and have a great day.